Welcome back to Financial Fortitude, the podcast that helps high earners, families, and business owners live well today and plan wisely for tomorrow. I'm your host, Michael Acosta, joined by my co-host, Brady Hemmerly.
Today we're talking about something that's easy to overlook, but can completely unravel even the most well-intentioned estate plan: beneficiary designations.
We're breaking down what Kiplinger calls one of the most common and costly estate planning mistakes, forgetting that beneficiary forms often override your will. That means your official estate plan might not be the one that actually gets executed.
We'll unpack the top 5 beneficiary assignment mistakes that you'll want to avoid, why they happen, and what steps you can take this week to make sure your loved ones are actually protected the way that you hope for.
Welcome to Financial Fortitude, a podcast for high earners, families, and business owners. We are your hosts, Michael Acosta
and Brady Hemmerly. Each week we bring purpose-driven financial guidance to you so you can be assured you're on the right path. If you're looking to become an extraordinary wealth builder, let's dive in. Michael, I am pretty excited about this episode as much as it is to get excited about estate plans, because I think it can be impactful. And there are a lot of important things that family members want to make sure get executed the right way, and in many instances don't, just because simple things aren't taken care of. So I think this episode is really focused on education first, and hopefully it's just a great reminder for everyone to go in and actually check what their estate plan actually looks like.
There are things that we're going to discuss today at a high level, and trying not to get pulled too deep into any sort of tax or legal situations or topics, but a lot of people overlook these common mistakes. And that's the things that we want to be able to provide you guys with the knowledge and wherewithal to be able to make sound, prudent decisions and set yourselves up for success as best as possible. And this one honestly will tie into one of our most recent episodes, 5 common open enrollment mistakes to avoid this year, episode 33, because in that process, you do have to assign beneficiaries. And if you don't do it right, well, you could fall victim to one of the mistakes that we're going to talk about.
So let's talk through higher or bigger picture thought first. Is talk more about how ultimately assets can pass from one family member to another. What options or routes can dollars take?
Yeah, so I would say, and you can correct me if I'm wrong, that there's really 2 to 3 different routes that things can pass at death to loved ones. And it's going to be a little bit different if you're married versus if you're single. So let's just start with if you're married. So if it's a non-retirement account, you're going to be able to have the opportunity to list what's known as, or apply what's known as, a transfer on death provision, TOD for short, or pay on death, POD. Okay. And so what that does is it triggers something very similarly to a beneficiary assignment that you would put on a life insurance policy, your retirement accounts at work, your personal IRA, your personal Roth, to where at death, the institution that holds those assets are notified if we submit a death certificate that they approve to go ahead and transfer the ownership of that asset to the designated beneficiary or beneficiaries if you're leaving it to your children, as an example, when you have 4 children. Without that provision, you're going to fall into what's known as a probate process, which is something that most people don't want to happen because it can be very costly. It's going to require litigation. You're going to be hiring attorneys, and the assets could be tied up for some time depending on what the probate process looks like and how crowded the court system might be. The third route would be by way of trusts. And it could be that the assets are already titled in the name of the trust. So at the time of death, there's really no disruption of the asset in some instances. And again, this is where we're not going to get too deep into the weeds from a legality standpoint.
So what I'm hearing here is assets can pass effectively by beneficiary, where I specifically list or name someone that I want to receive this asset. Assets can also pass by probate, which is really, and I'm sure we'll dive into this, what it looks like, but by the way of the state in the event typically where a beneficiary or a person is not named directly. And then the last method an asset can pass is effectively through title. Right? I may own an investment account jointly with someone. If I own an investment account jointly with my spouse, it's going to pass directly to them first. If I've gone ahead and titled an asset in the name of my trust, it's just going to pass through in the way in which it's titled. So 3 primary ways. Can you explain what probate actually is? Because I know a lot of us have probably heard the term, but unless we've actually settled someone's estate, have probably never actually dealt with it.
Yeah. So I'm going to give the formal definition that's been provided by Investopedia, which is a great resource whenever you're going and looking up specific terms within financial services or estate planning or tax planning. But probate is the analysis and transfer administration of estate assets previously owned by a deceased person. Okay, so when a property owner dies, their assets are commonly reviewed by a probate court. This court provides the final ruling on the division and distribution of assets to beneficiaries. A probate proceeding will typically begin by analyzing whether or not the deceased person has provided a legalized will. So just to summarize that piece, and then I'll give the last piece here in a second. It is going to be the process where we are giving up control over the review and assessment of the assets, our belongings that we have once we're dead. And we're putting it into the hands of the court system to determine and assess, were there acceptable legal documentations or instructions provided by way of will for us to go ahead and just streamline this process, or is it going to require us spending a little bit more time within the court system to figure out who these assets should be going to? Now, what this doesn't mention, at least at this point, is that when we die, our estates can be contested. It's public knowledge, unless you're taking appropriate proactive steps of putting assets in trust. In many instances, you could keep the assets sheltered or more private in nature.
So let's talk about that a little bit, because if I'm hearing you correctly, passing by beneficiary, if you list me as your beneficiary, in the event of your death, I just need to call my financial institution or your financial institution and say, I'm the beneficiary, and the assets just pass directly to me. If you haven't listed a beneficiary, or perhaps you have an asset like a home that you can't list a beneficiary on, right? That asset's going to go into probate, effectively fall into the court system state by state. And the state is going to help administer effectively where those assets go next and how long it takes. So why do people want to try to avoid probate? Because that's what we hear a lot of times from clients. I don't want to go through probate if I can help it.
I want to just make an additional distinction there, that even if you pass away with a will and you've assigned your executor, the person in charge, usually a family member or close friend, who's going to help with the distribution of assets to loved ones, you're still going to go through the probate process. It's just going to be less drawn out in nature, or should be, right? Because everything is almost predefined by way of the will. If you go through probate without a will or legal instructions, the state, the court, is going to assign an executor, someone who they believe is going to be able to assess the assets, the properties, and then distribute them accordingly based off of what they feel is prudent. So most people want to avoid that, because you're ultimately giving up the decisions to someone else who has no recollection or knowledge of who you were as an individual, outside of what's on paper, but also who your closest loved ones might be, or what your actual wishes were. So this is where it can be drawn out, because if they're going to have to go and interview or talk to multiple family members or loved ones or friends to figure out who you were as an individual, well, that's going to be timely, and there's going to be a cost to that. If your family is needing access to any of the assets to be able to bury you, to be able to resolve any lingering liabilities and debts, that's where it can become problematic, because they're now handcuffed away, kept out from gaining access to those assets until the probate process has been completed.
So some of the downsides, at least as I'm hearing it from a probate standpoint, is one, it takes time. I have to actually work through the court system to effectively finish what the estate finalization looks like. And that could be a number of months, if not over a year. The second challenge of probate that I'm hearing is there's a cost to it, right? I have to spend money, generally from the overall estate that I'm inheriting money from, to pay for effectively closing the estate. I think the last challenge that you had alluded toward is this idea of privacy. As things pass through probate, how does privacy look different compared to by trust or by direct beneficiary?
Yeah, so your greatest form of privacy is going to come either by beneficiary designation, right? So think about life insurance policies, retirement accounts, transfer on death, paid on death accounts, annuities. They're going to go directly from the institution that's managing them or servicing those assets to the recipient. So completely bypasses probate, which is highly private. This route is ideal when privacy and efficiency are priorities. Okay, so we can give you an example. The public won't know that my spouse or child or any sort of charity that I want to leave money to would receive, let's just say, $500,000 from a life insurance policy that I had on my life at my death. Depending on who the charity, the child, or the person is that I assign as my primary beneficiary, that $500,000 is going to go directly to them. Okay, so it doesn't go through probate. It bypasses it. Therefore, there's no public record of it. Now, by way of a trust, let's just talk about a revocable or irrevocable trust. This is going to be private mostly. We're not going to go deep into the weeds from a legal structuring standpoint when it comes to estate planning documents. But if the asset is properly titled in the trust's name, it should avoid probate entirely. Now, the trust document is not going to be filed publicly at death. Only the successor trustee and beneficiary will have access to this. So again, mostly private in nature. Now, creditors and disputes could come up, which could pierce the privacy if this were to go to litigation. Let's just say that I pass away, I have assets in a trust, and there's someone who believes that I owe them money. Well, they could spend the money to take my estate to court or the trust to court and try to gain access to the assets in there. Trust-based transfers generally remain confidential. But this is where we would want to consult with an estate planning attorney just to make sure that we have all bases buttoned up. Now, why does this matter? Well, because trusts are going to be the preferred route for families who want to protect privacy, streamline administration, and prevent the public from knowing their net worth or heirs. Now, if the asset is passed by way of will, even if you have the will, it's still going to be public record. Okay, because the assets are essentially titled solely in your name as the deceased. So there's no joint owner or beneficiary. So if it's just an account that I have in my name, my wife isn't jointly held on it, my wife isn't a transfer on death or a POD. If I pass away, that asset's going to transfer by way of will. It's going to go through the probate process. And now the executor that I've assigned in my will is going to be responsible for transferring that. It's public knowledge. Anybody can come and contest it, see it, and dispute where it should be going. The probate filings are going to include inventory of assets, valuations, distributions, the will itself. So it's all going to be public knowledge. So there's very little privacy, if any. And then again, anyone, creditors, ex-spouses, curious relatives, anyone can come and request access to it.
So as an example there, if I have no trust, no beneficiaries listed whatsoever, if I pass a life insurance policy to you for $500,000, if I pass a $500,000 home to you and a $200,000 IRA to you, right, there's public record that anybody can see and say, hey, well, Brady left Michael a $500,000 home, a $500,000 life insurance policy, and an IRA. If you have a curious relative or you have someone who may be looking into your affairs for whatever reason, they can just go straight to the clerk of courts and get all of that information. They now know effectively the inventory that you inherited from me.
Correct. And that's only if beneficiaries were not assigned appropriately, right?
Yep.
So just to overemphasize that.
So we made mention in the very beginning of our episode that we're going to go through some common mistakes here. And we've almost or started touching on one of them. So the biggest mistake that you see first in this world of estate planning, beneficiary designations, what is it?
Yeah, so the biggest one, number one on my list, is going to be not naming a beneficiary at all. So whether it's a bank account, whether it's an IRA, whether it's a Roth, whether it's a 401k, whether it's a life insurance policy, not having a beneficiary at all, right? So we already recognize that, hey, this could lead to some hiccups and some problems. You know, if you don't name a beneficiary for life insurance or retirement accounts, then the financial company that has it, that's overseeing it, holding it, is going to have the ultimate say and rule about where the assets will go after your death.
And I think we've all fallen victim to this, especially those who are busy professionals. And hey, I'm going to set up my 401k through work. I'm going to put my dollars in there, get the match, choose the investment plan, and then I never look at this document again, or I very rarely review it. And I just didn't have time to update the beneficiaries or add a beneficiary at the time. And then 3, 5, 10 plus years go by, and I've never even thought once to see, hey, who did I list again? Is it the spouse that I either had or didn't had when I set this thing up? Is it kids that are now should be the primary beneficiary or benefactor here? I would agree. What I see as a big challenge is looking at an account and saying, well, who's the beneficiary? And the client says, well, no one right now.
Well, and that's where hopefully your advisor's providing some context and education why you want to assign somebody, even if it's a close friend or a relative. And, we have young clients who are in the accumulation phase who will assign siblings, cousins, or even parents, right? And ideally, in a perfect scenario, the child's outliving the parent, but it's just there as a placeholder because if the client who is single now has any aspirations or has shared that in the future they would like to get married and start a family, well, it's just a placeholder for the time being. Specific to life insurance, as an example, if you pass away without assigning a beneficiary, the proceeds are going to be paid to your probate estate. So we just talked about what probate is and why that might not be attractive. And just to reiterate, this means that your family will need to hire a lawyer, go to court, and probate your estate to claim the proceeds. So in this Kiplinger article that really spawned this conversation today, titled Beneficiary Designations, 5 Critical Mistakes to Avoid, and we'll put all this in the show notes as far as the link itself for you to be able to go check it out yourself. But the sentence where it says, your family will need to hire a lawyer to claim the proceeds. These are already assets that are in your family, but you're having to jump through hoops to gain access to it. That's not what you want to do during a time of grieving. For retirement benefits, if you're married, Brady, you mentioned this early on, your spouse is most likely going to receive the assets without any sort of hiccups, typically. Now, this could be drawn out. This could take months. It may take a year, depending on the institution and the forms and whether or not you're in the process of moving and having to update mailing addresses and all that stuff. But if you're not married, the retirement account will likely be paid to your probate estate. Now, this could lead to some unpleasant income tax ramifications. When the estate is the beneficiary of a retirement account, all the assets will need to be paid out of the retirement account within a 5-year period of death. So now we're talking about the acceleration of the deferred income tax, which must be paid earlier than would have otherwise been necessary depending on who the beneficiary assignment was. If it would have been my spouse, then we would have had the opportunity to drag out the distribution, especially if I'm passing away before required minimum distribution age. If it's going to a child, then because of the Secure Act 2.0, they would be subject to a 10-year distribution rule.
I would say summary-wise, I think the biggest mistake that we see is just leaving off beneficiaries altogether. And the fix is easy. It's just naming someone. Even if you don't have the perfect person to name at the time, it's better than assets potentially falling into probate and then spending quite a lot of time and money to get access to dollars, your family, to get access to those dollars that would have otherwise been yours or theirs if they had just put the beneficiary designation down.
Correct.
So beyond just simply naming a beneficiary, what do you tend to see as a next either big mistake or consideration when it comes to who do I name or whose name?
Yeah, number 2 in my mind is going to be failing to take into account special circumstances. So let's talk about special circumstances. Most commonly, it's going to be naming minors or individuals with special needs or even loved ones who maybe have addiction problems or who are just really bad with managing money. If we overlook those circumstances, it can lead to a couple things. So let's start with the minors first, because I think that's the simplest to dissect. I have 4 children. If my wife and I get on a plane and we both pass away, and everything from a contingent beneficiary standpoint, not the primary, but the contingent are my children, all of them are under the age of 18. They're all minors. Well, assets are going to transfer to them, right? Either by way of direct transfer or probate through my will that we have. However, because they are minors, it is going to require conservatorship, right? Now, what that means is that the court is going to assign a conservator to actually oversee the management of these assets on behalf of my children, at least until they become the age of majority. And so each state's going to be a little bit different, which is why we don't want to get too deep into this. But this could lead to other costs because there are going to be costs associated with the conservator. There's going to be costs associated with the court. And if there are annual reviews that are being assessed for accounting and auditing the accounts while the children are still minors, that's going to be paid out from the assets or out of pocket by someone else. So the question you really have to be able to answer is, if I pass away and my assets are going to my child who is a minor today, do I want to give up control to a stranger or open up the opportunity for there to be litigation issues where if I've assigned my siblings to be the guardian of my children, well, even though they're the guardian, the assets were paid directly to the child, which means the guardian's probably going to have to go to the court system, get a lawyer, and try to fight to get the assets moved under their purview.
So what would you say is a potential fix to something like that?
Yeah, so if you've gone through the process of estate planning and you've established your wills and your, living will, durable power of attorney, healthcare power of attorney, guardianship, there's 2 to 3 ways of going about it in my mind. One, if you're getting a trust established, name the trust as the contingent beneficiary. You can make your spouse as the primary. If both of you pass away simultaneously, it would go to the trust. Okay. Second, you could have testamentary trust language in your will. Now, this isn't bulletproof because things are still going to go by way of probate, so it's still public knowledge, but the will in a simple form should instruct the estate to establish a trust for the benefit of X, Y, and Z, your children in this scenario, and the assets that have already been identified should go into that newly formed trust. So some estate planning attorneys, most, will provide you with testamentary trust language that you can put into your contingent beneficiary line item whenever assigning it. The third would be just to make the guardian, if you want to, the beneficiary or the contingent beneficiary. So at the time of death, it passes to the guardian who's going to be taking care of the children. The problem with that is that they could mismanage those assets because it's going to be going to them. So now it's their asset that they own, not an asset that your children own.
So special circumstances, kids under 18. I also heard you mention things like individuals who can't really manage money to a certain degree, who may have mental health challenges. Like, what do all those things look like, or what comes to mind there?
Yeah, in that scenario, trust is probably going to be the best form, right? And this is where you'll want to consult with your financial advisor and estate planning attorney just to make sure that, hey, we're putting these assets in a vessel or vehicle to where they don't have direct control over, but you can assign a trustee, someone that you trust to oversee it and manage it and work alongside them as a mentor, more or less, to make sure that they don't overspend the money, that they don't get taken advantage of, or that they don't, just make terrible decisions that completely squander the wealth that you might be leaving them that's supposed to be there to support them. Now, the third one is children with special needs. And this can be a topic all in itself. But if you have a child with special needs, you don't want to leave the asset directly to them, because if they're receiving any sort of government benefit or support, if they receive a large amount of wealth by way of inheritance that's directly in their name, then it could eliminate and make them ineligible for those government benefits that they're receiving.
So what I'm hearing here is, when there is a special circumstance, whether it's kids under 18, kids with special needs, individuals who may not be the best money managers or aren't equipped to be the best money managers, one of the more overlooked things is just building in that extra layer of protection and privacy for those individuals prior to a death, rather than letting the probate, the court system, and potential litigation make all of those decisions for us.
Correct. And that's where you're just going to want to work with your team of advisors, right? Your financial professional, your tax planning professional, CPA, and estate planning professional.
So this kind of goes hand in hand with another one that we see often from a mistake perspective. We have worked towards naming a beneficiary and taking account for special circumstances. Talk to us more about what we see oftentimes just about forgetting to make changes, because I think this is a big one.
Yeah, so forgetting to make changes is a big one. And this is where the benefit election episode that we referenced early on is almost timely, because every year you're forced to go in and make updates to your benefit elections, whether you're going to opt into group term life insurance, supplemental, spousal, child, or dependent. Again, you have all these different benefits that you can opt into that you're reviewing, but we may not take time to actually go through and review the beneficiaries that we've assigned previously. So when would you want to adjust these? Well, if my wife predeceases me and it's just me and my children, well, she's been the primary beneficiary of all my assets at this point. So going in and updating it appropriately to where if my children are minors, like we just talked about, setting up the appropriate vessels or plumbing to be able to get the asset into an appropriate vehicle on their behalf, right? So that someone else, a stranger, is not managing it and not respecting my wishes for them. Also, if I get divorced, right? We had an episode on divorce and what to expect and how assets would be divided. But if I get divorced, I probably don't want the death benefit to go to my ex-spouse, especially if they get remarried or if there was bad blood there. Now, if you got divorced on good terms, you still might make them the primary beneficiary with the understanding that, hey, if I pass away before our child or children are of the age of majority, this is going to you for their benefit, for their support. Hopefully, you can get a legal document drafted that, hey, this is outlining what this is for should this happen. But once they become the age of majority, you would go back in and just change it to be the children directly.
What problems do you see here or have you seen here from a, I would say, marriage, divorce, second marriage, mixed family standpoint?
I would say that what would be most common is that you overlook updating this, you pass away untimely, and because you never modified it, let's just use the example of divorce, it goes to your ex-spouse, and you may not have a good relationship with your ex-spouse. Your children may not have a good relationship with your ex-spouse. The spouse could have been abusive, and so your children have no communication or anything like that with them. And so now your children are being neglected, and this could lead to additional litigation if the guardians know that, hey, this wasn't a good situation. That money should, in theory, be going to the benefit of the children for their care, not to this ex-spouse. Or if it's a couple that got remarried, right? Or if it's a blended family, same concept.
Yeah, that's what I've seen is husband and wife or couple get divorced. Beneficiaries are not updated, so funds go to ex-spouse when the true intent are for funds to go to kids, either grown or minors. The other one that we see oftentimes from a mixed family perspective is, hey, maybe I got married much, much earlier in my life, and I have since been remarried and have children with my second marriage. If my ex-spouse from many, many years ago was still listed, he or she who inherits some portion or all of the dollars from that perspective may not have any relationship with my children from my second marriage, who I may ultimately want to receive assets. So I have seen in some instances where kids really get disinherited from an estate just because beneficiary designations haven't been updated to account for, I would say, life changes as life progresses, at least.
Right. And the next mistake, number 4 in my mind, is kind of building off of the first couple that we've discussed, right? Not only did we not assign one, are we overlooking the situation of who we're assigning? Did we forget to update the beneficiary's information? But this fourth one in my mind is getting the name wrong altogether, just spelling it incorrectly, or knowing that people's names change over time, whether it's, a child who's getting married and changing their last name, right? My spouse legally changed her name altogether because her entire life she went by her middle name. We got married. She basically moved her middle name to her first, moved her last name to her middle, and then took my last name. Or you might have a child and they become junior or the third, or, your name is now senior if, in that circumstance. So just making sure that when you are reviewing your beneficiary assignments, which should be done at least once per year minimum, right? You and your financial advisor should be doing this, or you and your family should be doing this once a year at a minimum. As you're reviewing it, just making sure that everything is buttoned up as far as spelling convention, updating mailing addresses, phone numbers, social security numbers, date of birth, so that if something is incorrect, that there are multiple ways for the institution to be able to confirm who the appropriate recipient is, which kind of leads us into the fifth one.
Yes, I'd say the last thing from a maybe mistake perspective is not the right word, but just an overall coordination perspective. The education that we provide clients is that your estate plan between how you title assets, what beneficiaries you list, and how your will is drafted all need to be coordinated because some designations are going to supersede others. And the example that we oftentimes give there is if my will says everything is going to my spouse, but my beneficiary designation on my life insurance says everything is going to my oldest child, typically the beneficiary designation is going to supersede or get first preference on how assets pay, even if that is not the intention that I have from an overall planning perspective. So it's very important to coordinate how are my assets titled, how are my beneficiary designations listed, and does the will or other estate documents that I have actually match and coordinate with all of the other pieces and designations that are out there? Because if they contradict each other, there's not a lot of recourse for particular beneficiaries to come back and say, well, actually, I'm in the will. No, you weren't at the beneficiary designation.
And at the end of the day, the beneficiary designations are really designed, to your point, to ensure you have the ultimate say over who will get your assets when you are gone. Again, you can't overemphasize this because we've seen it in client experiences, client situations where someone passes away, everything wasn't buttoned up, Things were overlooked. And now during this grieving process, it's devastating to the surviving spouse and family because, again, they need access to those assets in some capacity. Maybe not always, but we've seen it where children are having to scrounge money together to pay for the funerals and final expenses. They're putting it on a credit card. It's taking months on end to be reimbursed. And so it creates other compounding financial strain on those that you've left behind. And that's ultimately what we're trying to avoid. So one of the things that we have is a resource that we can provide called What Issues Should I Consider When Reviewing My Beneficiaries? It's a simple yes or no checkbox beside each consideration with a little bit of a explanation of what we're speaking to. So as an example, the first one is, do you need to review your beneficiaries to ensure they are up to date? Yes or no? If the answer is yes, then you know that you should probably take those steps, right? And hold yourself accountable to doing that and putting some time on the calendar. So again, simple resource. We'll be sending this out in the email distribution of this episode once it goes live for you to be able to make prudent and sound decisions around your financial plan so you can continue to maintain your financial fortitude.
So, Michael, if you were to summarize this episode in a very basic sense for listeners, what would you say you'd like listeners to take from it?
So the biggest thing would be that don't overlook something so simple as assigning beneficiaries. It's best practice to assign a primary as well as a contingent, right, or secondary. Very seldomly do we see a third, but if we're updating this at least once per year, we're staying ahead of the curve. And as life happens, as it does so often, we're making those necessary changes. If there is a triggering life event, death in the family, the establishment of a trust, or a change to your wishes from a will perspective, that's going to require the updating of beneficiaries, right? A divorce would be another one. Having children or becoming a grandparent. These are all things that might trigger reviewing your legal documents from an estate planning perspective, as well as the beneficiary assignments. The next thing I would say is that most people do not want to die in what's known as intestate. It sounds terrible, but what it basically means is that you're dying without legal instructions. So everything that you have that doesn't have a beneficiary assignment, like a paid on death, transfer on death, or just a direct beneficiary, is going to go through the probate process. It's all going to be public knowledge, and you don't want that. And then the last piece is, again, you can't overemphasize. This is so simple. You want the end of your show to be enjoyable for your loved ones as best as possible, as weird as that sounds. You don't want them searching through mounds and mounds of paper, reaching out to multiple institutions, fighting with them to get access to assets, and just dealing with the headache of having to meet with attorneys, go to court, and all these other hurdles to get what's rightfully owed to them based off of your wishes.
And I think that's where we see it most meaningful for people. At the end of my show, I want the memories and legacy I leave behind, the time, the experience, the enjoyment that I had with family, and ultimately my legacy from a financial perspective, just to be an easy transition. I wouldn't prefer my legacy to be, when Brady died, it took months and months and work to get things settled just because he hadn't gone through some of the basics or hadn't looked to update things in quite a while.
Absolutely. And with that, we're going to go ahead and wrap up the episode. And so thank you for tuning in. Hopefully this episode gave you a reason to dust off those old beneficiary forms and make sure what's written actually reflects your intentions.
And remember, the best estate plan is the one that actually works when it's needed and most. So don't wait until it's too late to verify your designations and coordinate your documents.
And if you found this helpful, make sure to subscribe, leave us a review, and share this episode with a friend, family member, or colleague who's doing their own estate planning.
And if you've got a personal question you'd like us to tackle on air, submit it anytime through our Ask Us Anything page at www.genesiswealthplanning.com. The link should be in the show notes.
Until next time, stay organized, protect wisely, and continue building extraordinary wealth.
Are you considering hiring a financial advisor? If so, be sure to listen to episode 1 of Financial Fortitude. In this episode, we discuss the reasons why many people choose to hire a financial advisor and highlight the key qualities you should look for in the financial professional you decide to work with.
This podcast is for informational purposes only and is not to be construed as tax, legal, or investment advice. Although the information has been gathered from sources believed to be reliable, please note that individual situations can vary. Therefore, the information should be relied upon only when coordinated with individual professional advice. Guest speakers and their firms are not affiliated with or endorsed by Park Avenue Securities, Guardian, or Genesis Wealth Planning LLC, and opinions stated are their own. Guardian, its subsidiaries, agents, and employees do not provide tax, legal, or accounting advice. Consult your tax, legal, or accounting professional regarding your individual situation. All investments and investment strategies contain risk and may lose value. All scenarios and names mentioned herein are purely fictional and have been created solely for educational purposes. Any resemblance to existing situations, persons, or fictional characters is coincidental. The information presented should not be used as the basis for any specific investment advice. Michael Acosta and Brady are registered representatives and financial advisors of Park Avenue Securities, LLC, PAS. Securities, products, and advisory services offered through Park Avenue Securities, member FINRA, SIPC. Financial representative of the Guardian Life Insurance Company of America, Guardian, New York, New York. Park Avenue Securities is a wholly owned subsidiary of Guardian. Consolidated Planning Group, Inc. and Genesis Wealth Planning, LLC are not affiliates or subsidiaries of Park Avenue Securities or Guardian. Michael Acosta's California Insurance License Number 0M50974 and Brady Hammerly's California Insurance License Number 4353077.
7237198.23 expiration 1127.